All right, we move now to Learning Unit 5, Crime Against the Administration of Justice. When you have worked through this learning unit, you should be able to show that you understand the requirements for certain crimes relating to administration of justice by being able to explain the possible liability of an accused for the crimes of common law, perjury, statutory perjury, defeating or obstruction the cause of justice, and contempt of court. Common law perjury to Pet, Chapter 8, definition. Common law perjury consists in the unlawful intentional making of false declaration under oath or in a form allowed by law to be substituted for an oath in the course of legal proceedings. Elements of this crime are the making of a declaration which is false under oath or in a form equivalent to an oath in the course of a legal proceedings in an unlawful and intentional manner. False declaration. This requirement comprises of the following. The declaration must be objectively false. The declaration may be orally or in writing in an affidavit. The falsehood may be made either expressly, impliedly. If it is made impliedly, the prosecution relies on an innuendo. In Valba 1911-32 NRL 9, for example, it was decided that the words of a witness, "I have already stated what I heard," implied that the witness had heard nothing more. Under oath or in a form of substituted oath. The declaration must be under oath or in one of the forms allowed to be substituted for an oath, namely an affirmation to tell the truth or a warning by a presiding official to the witnesses to tell the truth. In the courses of a legal proceedings, the crime is committed only if the false declaration is made in the course of the legal proceedings. Extrajudicial false sworn statements are also punishable, but not as common law perjury. They can be punishable in terms of Section 9 of the Act 16 of 1963. An extrajudicial statement is a statement made outside the court concerning the matter which has nothing to do with the dispute decided in court. The legal proceedings can be either a criminal or a civil case. False sworn statements made before an administrative tribunal do not constitute the crime. Thus, it was held that such declaration at a meeting of creditors in terms of the Insolvency Act cannot amount to perjury. Castle 1967, Section 2 SA 259C. In Buchman 1954 SA 261, It was decided that perjury can be committed by the making of a declaration outside the court or before a case has begun, provided that such declaration be permissible as evidence at the subsequent trial. The maker of the declaration foresees the possibility that it may be used subsequently in a trial. According to this test, therefore, perjury can be committed by making a false statement for the purpose of a civil motion proceedings, which is mostly in writing, to Doit 1952 SA, but not by making a declaration which a false criminal charge is lodged, or by making an extrajudicial sworn statement to the police in the course of their investigation of a crime. In the Buchman case, it was decided that the extrajudicial statement made to a police officer are not normally used in a subsequent trial as evidence, or consequently they are not declarations made in the course of a legal proceeding. The fact that false declaration is made in the course of a case of which the judgment is later set aside on appeal is no defense. The position is the same if the warrant for the arrest of the accused was invalid. Unlawfulness. The fact that shortly after making a false statement, e.g. in cross-examination, the witness acknowledges that the statement was false and then tells the truth is no excuse. Baxter, 1929. In addition, the fact that the false declaration made in a vain attempt to raise a defense is also no excuse. This happens daily in our courts, but for practical reasons, not every accused whose evidence is rejected as false afterwards charged with perjury. Intent. X must know, or at least foresee, the possibility that his declaration is false. Mere negligence or carelessness is not sufficient. Mokoena, 1984. Statutory perjury. You must study the discussion of this crime in Joubert, chapter 8. This crime is set out in the section 319, subsection 3 of the Act 56 of 1955. Note that for examination period, you must be able to briefly describe the contents of the section, state the reason why the legislature created this crime, state what the state has to prove when prosecuting a person who contravention of the subsection, state the points of difference between common law perjury and this crime. Defeating or obstructing the cause of justice. You must study the discussion of this crime in Joubert chapter 8. The elements of the crime are an act which defeats or obstructs the cause of justice in an unlawful and intentional manner. Note the different names given to this crime, the difference between defeating and obstructing the cause of justice. The various interesting ways in which this crime can be committed. The rule that the crime may be committed even though there is no pending case. The intention requirement. The meaning of the expression administration of justice. The fact that the person can be charged with attempted to commit this crime, and the charges of attempt are in fact more common than charges of having committed a completed crime. Activity. X, who is angry with her boyfriend who was unfaithful to her, lays a charge of rape against him at the police station. The police investigate the matter and find out that X laid a false charge. Can X be charged and convicted of defeating or obstructing the course of justice? Yes, because even pre-trial procedures involving investigation of offense by police officers are considered part of the proceedings of the administration of justice. See Joubert Chapter 8. The offense need to not be committed in relation to a pending case. The accused ought to only have foreseen the possibility that her conduct may lead to obstructing or defeating administration of justice if they were to take place. If the perpetrator has performed any act that has a tendency to undermine any process that is part of the administration of justice, she would have committed this offense. Contempt of court. Definition. Contempt of court consists of the unlawful and intentional violation of the dignity, repute, and authority of the judicial body or judicial officer in his judicial capacity, or the publications of information or comment concerning the pending judicial proceeding which has the tendency to influence the outcome of the proceedings or to interfere with the administration of justice in that proceeding. Elements of the crime. The elements of the crime are the following. A, the violation of dignity, etc. for the judicial body or judicial officer. Or B, the publications of information, commentary concerning the pending judicial proceeding, etc. in an unlawful and intentional manner. Unusual characteristics. The crime has following unusual characteristics. The act by which the crime is committed can be divided into various groups, some of which have very distinctive requirements, e.g. the requirement that the case must be sub judice. The legal proceeding has not yet been completed. In the case of the publication of information which potentially prejudicial to the just trial of a case, the crime can therefore be subdivided to a certain extent into a number of sub-crimes, each of which has certain distinctive requirements. As a rule, some cases of contempt of court are not even treated as criminal cases, but as civil cases. In the civil courts, however, it has been held that these cases can also come before courts as criminal cases. At the same time, if the Director of Public Prosecution chooses to bring the case before criminal court, reasons for the existence of crime. Contempt of court is punished not to protect the dignity of an individual judicial officer, but to protect the administration of justice. The violation of the dignity or repute of a judicial officer undermines the respect of the public for the court and the administration of justice, and consequently the whole legal order. In the case of contempt committed by the publication or information or comments on the pending case, the reason for the crime is that the court should come to a decision only on the grounds of permissible evidence before it, and ought not to be influenced by the disclosure of facts or comments from outside, such as those in the press. Conduct. A distinction is drawn between the contempt in facie curia and contempt ex facie curia. In facie curia literally means in the face of the court, and the contempt of this form is contempt in the presence of the judicial officer during the session of the court, such as when the person should shout, sing, and dance in court. Contempt ex facie curia occurs through actions or remarks out of court and can take a variety of forms, such as scandalizing the court by the publication of allegations which, objectively speaking, are likely to bring judges or magistrate or administration of justice through the courts generally into contempt, or unjustly to cast suspicions on the administration of justice. Mamabolo 2001. Failure to comply with the court order, publishing the information or commentary calculated to influence the outcome of the case that is still under consideration by the court. Unlawfulness. Statement by members of certain bodies such as Legislative Assembly, when present in the assembly, are privileged and cannot amount to contempt, seeing Section 51 and 71 of the Constitution of the Republic of South Africa. Of importance is the rule that fair comment on the outcome of the case or on the administration of justice, the general, does not constitute the contempt of court. Public debate on the administration of justice is in fact not only permissible but also desirable in a community such as ours, to ensure that law and administration of justice enjoy the respect of the population. Intention. In general, intention is essential element of the crime, Faneke Supra, except in cases where the editor of the newspaper is charged with this crime on the ground of the publication of his newspaper or information concerning pending case, which tends to influence the outcome of the case. Culpability in the form of the negligence will be sufficient to establish contempt of court in such circumstances. Administration of justice by courts. The language complaint of must be directed to a judicial officer in his judicial capacity or at the administration of justice by court, criticism of the performance of a mere administrative function such as the actions of the police or criticisms or alleged unreasonableness in acts of parliament is not contempt of court. Sachs 1932, Dlamini 1958. Glossary. In facie cautere in court or in the face of the court. In ex faciare outside the court. Sub judice. Still sub judice. Still under consideration by court. Summary. General. The definitions and elements of common law perjury, statutory perjury, defeating the obstruction of cause of justice and contempt of court are to be found above or in the relevant portions of the prescribed books. Perjury. In common law, perjury must be false declaration. Declaration must be objectively false. The declaration may be an oral or writing. The common law perjury, the declaration must under oath after an affirmation to tell the truth, or in case of children after the warning to tell the truth. In common law, perjury declaration must be made in the course of illegal proceeding. These are two differences between common law perjury and statutory perjury. In the statutory perjury, there are always two statements involved, whereas the common law perjury only one statement is required. In statutory perjury, it is not necessary that the statement is made in the course of judicial proceedings, as is required for the common law perjury. Defeating or obstructing the cause of justice. There is a difference between defeating and obstructing of justice. The last mentioned is something less than the first mentioned. The following types of conduct may amount to the crime of defeating or obstructing the cause of justice: interfering with the witnesses, tampering with the democracy, with the documentary or evidence, obstructing the police in relating to particular proceedings. It is not a requirement for this crime that the case must be pending. Even the pre-trial procedures involving the investigation of offences by police officers are considered part of the process of administering justice. Charges of attempting to defeating or obstruct the cause of justice are more common than charges of actual defeat or obstruction. Contempt of court. One of the unusual characteristics of this crime is that it can be divided into several sub-crimes, each with a requirement of its own. The distinctive drawn between the contempt in facie cautere committed in court and contempt ex officio cautere committed outside court. One of the many ways in which the contempt of court can be committed is by scandalizing the court. Remarks amount to fair comment of administration of justice or on the outcome of the case are not unlawful and do not constitute contempt of court. Contempt of court in facie cautere takes place when acts behave in such a way in a court that violates the integrity and the authority of the judge, magistrate, for example, by singing loud in court. In such a case, the judge or magistrate can summarily convict and punish X. Commentary on pending cases constitutes contempt of court if it is calculated to influence the outcome of the case. And then we test ourselves here. Then we're going to stop here.